Can you exclude the shots to the head for Mr. Williams and Mr. Thomas as coming from outside of the car?
Yes.
Testimony that throws cold water on the claim in the YNW double murder trial that the shooting that killed 2 young rappers was a drive-by. These are the top moments from week 3 in the trial of Jamel Demons.
Introducing the next generation of pepper spray. Meet Palm, a new maximum strength self-defense product with a patented modular design, revolutionizing the self-defense industry. Whether you're carrying the unit on your keys, snapping the unit on your backpack, your keychain, or carrying the unit in your pocket, Palm is the perfect everyday carry accessory. Palm's patented flip-top safety prevents any accidental misfire, and its maximum strength formula provides you with the necessary range and capacity to bring peace of mind to you and your loved ones. Quality, safety, performance, peace of mind. Learn palmpepperspray.com. I'm Anjanette Levy, and welcome to Law and Crime Sidebar Podcast. We just wrapped up the 3rd week of YNW Melly's double murder trial. It started out with YNW Melly's text messages and gang affiliation. Then it moved on to the medical examiner and an expert in bullet trajectory and crime scene reconstruction. Melly faces the possibility of the death penalty if convicted of 2 counts of first-degree murder in the shooting deaths of Chris Thomas Jr. and Anthony Williams in October of 2018. Thomas and Williams were part of the YNW Collective and went by YNW Juvie and YNW Sack Chaser. Melly's co-conspirator, Cortland Henry, who went by YNW Bortland, also faces charges in their deaths and will be tried separately at a later date. Melly, whose legal name is Jamel Demons, faces the possibility of the death penalty under a lower threshold of an 8-4 vote by the jury. That was signed into law by Governor Ron DeSantis this past April. The week started off with Danny Polo, the state's gang expert. He told the judge during week 2 that $50,000 bounty on his head because of his work, so he asked to wear a mask. The defense objected, saying the jurors and Melly had a right to see him. The judge let him wear that mask. Polo has also testified in the XXXTentacion trial and others as an expert. But first thing on Monday, the defense brought up the mask again.
May I inquire from the witness?
Sure.
Sir, are you aware that on with your family is on the internet as we sit here today?
Nope.
May I approach?
You may.
May I show you what is a picture and ask if that is you and your family?
Yes, sir.
And that's on your wife's Cash App?
Yes, sir.
Which is available to anyone who runs that, because we just ran it this morning.
I guess so. I did my best to keep things clean. I guess I missed that one.
We would object to him continuing to testify with his mask on based upon that public record.
Detective Polo was clearly surprised that his photo was on the internet. The judge said the mask had to come off, but that the cameras could not show his face. The prosecutor, Christine Bradley, presented text messages from Melly's phone before and after the homicides through Polo's testimony. In the 2 weeks before the homicides, Melly was clearly looking for a gun.
On page October 14th of 2018. Can you read that one and then explain what it's meaning?
9807 number asks, you know someone selling a glizzy? Glizzy is a slang term for a Glock.
Okay.
Then Polo showed another text after the homicides. The state says it shows Melly was a member of the Bloods G-Shine set.
There's a message from, again, the genome to the 9807 phone number. If you could read that message aloud.
Are you a Ruru? I was thinking you should drop a few chains and give them to the gang. That'll show people who you connected with. It's not mandatory, just a thought.
Okay. And the response.
Not everybody, of course.
Is there a dues or tithing that's required as for membership in a criminal gang?
Yeah, as described in the oath and many times throughout the Bible, it's not about the individual, it's about the collective. The mere mere fact that he wasn't even communicating with Gino and with his lineup enough, that was enough for them to say, you're not doing enough for us. And now, to step further, we need to be brought to these shows, and you should buy us some jewelry, because that jewelry's not cheap.
Okay, so then the next message from December 12th says you're in the position to be a young Don. What is a young Don?
Higher up, captain.
Okay. Is that one of the ranks?
They didn't reference that name as in their Bible as what they call their ranks, so I think it's just like a term related to the mafia, Don.
Okay. And the response from the 9807 phone number is?
Let's do it.
Okay.
On cross-examination, Melly's lawyer questioned Polo about whether Melly was really a Bloods member.
We were also speaking yesterday about the fact that Melly was largely unresponsive to many of the overtures that were being made, the attempts to recruit him. Right?
I think he was already recruited, but what you're saying is he wasn't responding to the people that were messaging him.
Okay.
Within the organizations.
Okay. And I had gone through a list or a demonstration of several messages that were not being responded to, right?
Correct.
And I think I had asked you later on in my examination whether that was Gino, and you were like, no, that's not Gino.
Yeah, we went through two different, I think, text threads. One was Gino and one was Herc.
Okay.
The jury also heard testimony from the pathologists who performed the autopsies on Chris Thomas and Anthony Williams. Dr. Rebecca McDougall performed Sack Chaser's autopsy.
The first injury to the head, was it?
Back of the
head was the fatal injury, right?
So in this case, that's the fatal injury because the other two, he was dead when they were inflicted.
So this person, when the other two were already deceased,
Correct.
did not suffer any pain from those two injuries.
He's already dead.
Fair enough. And you indicated that these injuries were indeterminate,
Correct.
which means, in layman terms, simple terms for me to understand, means that you cannot tell how far away or how close shooter or shooters were
Correct.
when this occurred.
Yes, sir.
And Dr. Adrian Souter performed the autopsy on Chris Thomas, who is known as YNW Juvie.
Can you show the mark that you placed on that would be equivalent to the mark A on Christopher Thomas's face?
So the entrance wound would be approximately right here on the cheek.
And in terms of where the occipital bone, where you said that the impact or the terminal location of the bullet was, where would that be on that?
So in order to accurately depict that, you would have to open the brain, and if I don't do that, then approximately right here, but on the inside.
And so if you could just turn around and show that to ladies and members of the jury and point to it. Okay. Moving on to the next photo, C. Does C line up with B? Is that the other side of the hand?
Yes.
Can you tell if this is an entrance or an exit wound?
No.
Same reasons as for B?
Yes.
Oh. In terms of wound D, what are we looking at here?
D is a defect to the D is the entrance wound, medial lateral aspect, medial dorsal aspect of the left foot.
And if you could explain what dorsal means.
Posterior.
Okay. And how can you tell that D is an entrance wound?
Because of the characteristics of the wound and because it has an abrasion margin.
In terms of the order in which you label from A to D, are you suggesting in any way that that's the order the wounds were inflicted?
No.
The state then called Sergeant Christopher Williams, who is a crime scene reconstruction expert, to really explain what those autopsy results meant and how the shooting occurred, in his opinion. He testified that shots fired inside the SUV killed Juvie and Sack Chaser.
So Mr. Williams was not even aware he was about to be shot. When Mr. Williams was shot, Mr. Thomas puts up his hands and is shot, and then is shot again.
Okay.
There's no time for anybody to switch a firearm. If there were, I believe one of those individuals would be alive. There's no time to switch. It was a very, a rather rapid event of firing.
Can you say the length of time between the fatal shots and then the staged drive-by shots later on?
It was enough time for the heart to stop beating, for there to be no circulation due to the wounds that I examined from the medical examiner's office. None of the wounds have any blood in them, which tells me that they're all ante-mortem wounds. So the time was long enough for the heart to stop beating.
Okay. Is there scientific or medical testing to recreate that in any way, shape, or form?
Yes, it's knowledge. It's I'm sure the medical examiner could say the same thing.
So in terms of, it's nothing that can be recreated with a live human.
Correct.
In terms of the number of shots outside the car, how many rounds were fired inside of the car?
3.
And can you exclude the shots to the head for Mr. Williams and Mr. Thomas as coming from outside of the car?
Yes.
The defense really couldn't shake Sergeant Williams, although they tried. He was confident in his assessment that Juvie and Sack Chaser were shot inside the SUV.
What's the best way to get an idea of how big the inside of that car is?
You can measure it, or you can also view it.
And where is that car right now?
Car is in the crime scene unit forensic processing garage right now.
Is it available for the jury to view this morning?
Yes.
Now, the jury didn't get to see the car this week because security needs to be arranged for the jurors to see it. But that could happen next week. Jurors will get an up-close view of that SUV. On Thursday, prosecutors told Judge Murphy they plan to call Chris Thomas Jr.'s mother to testify.
And are you related to one of the decedents in this case?
Yes, I am.
How so?
His mother,
And who is that?
Christopher Thomas.
The defense did not want Chris Thomas's mother to take the stand. They were concerned it could cause a mistrial if the testimony became too emotional. But she was called for a very limited purpose, to identify the people leaving the recording studio on October 26, 2018 at 2:19 a.m., shortly before the murders.
Positive 2/19/15. Ms. Phillips, did you see who entered into the occupants who entered into that gray Jeep?
Mm-hmm.
And is that a yes?
Yes.
Do you recognize where your son entered that gray Jeep?
Yes.
Which seat? If you can identify for the jury.
Right hand side.
Do you recognize the individual that got into the back seat on the left side, the rear driver's side?
Yes.
And who was that individual?
Janelle.
And Jamel, is that the defendant, Jamel Demons?
Yes, ma'am.
And do you know him by
Melly.
And do you see Melly Jamel Demons in the courtroom?
Yes, I do.
And you identify him by an article of clothing and where he's sitting in the courtroom?
He's sitting over there. He have a tuxedo. I think it was for.
Leandra Phillips's testimony was brief. You could see she's been through so much, losing her son, and now sitting through this trial. And really, she's sitting there watching this video of her son moments, minutes possibly, before he was murdered. So she's watching him get into this vehicle basically running to his death, not ask her any questions, which was likely a very smart move.
Ms. Phillips, we want to express our condolences to you.
Thank you.
After that, the prosecution showed the jury more than 300 videos and photographs from the phone the state says belonged to Melly at the time of the murders. The defense has raised the possibility that Melly wasn't the only person using the phone number that ended with 9807. The name on the phone is actually Young Sack Chaser. The phone includes many texts to Melly's mom and also other rappers, including the murders. To prove to the jury that this phone indeed belonged to Melly and was in his possession before and after the murders, Assistant State Attorney Christine Bradley showed the jury each video and photo, one by one, that show Melly holding the phone or photographing himself with the phone, taking a selfie. Investigators extracted the videos and photos from that phone. And on Friday, Cortland Henry, who is YNW Melly's co-defendant in the case, appeared in court for a status hearing, and his attorneys were asking to modify the conditions of his release.
Judge, if the court, when we were here last time, you let him go to church and stuff, you said about working, you would be subject to seeing his schedule. We found the schedule a couple of months. I saw that. And he would like to be able to work. And I talked to his probation supervisor. She has no problem with him at all. She said that if he's going to go to work, he'd like anybody has to do, provide an itinerary, where he's going to be, how he's going to get there, how it's going to get done, when he's going to be back, and the normal check-in, drug testing, everything that goes with that.
This schedule includes, locations all across the eastern seaboard and Midwest in terms of the ability to supervise for probation and pretrial, rather. That is almost impossible. With regards to the time frames and all of the studio in issues on that, I don't understand why they have to be until midnight or 11 p.m., why they can't be done during other hours on that. So the state would object. He's already shown prior issues with pretrial. So for those reasons, the state would say that the current schedule only needs to be maintained for another 3 or 4 months at this point before we'll be in trial.
Respect the motion tonight. All right. Thank you.
Portland didn't look very happy as he left court after Judge Murphy denied his request to modify his bail to allow him to travel. He remains on house arrest and his trial is scheduled for October. The trial of YNW Melly is dark next week. The 4th of July falls at that time. Testimony will resume the following week, and we will, of course, have it covered for you on .com and Law and Crime's YouTube channel and on the Law and Crime Trial Network. And that's it for this edition of Law and Crime Sidebar Podcast. You can listen to and download Sidebar on Apple, Spotify, Google, and wherever else you get your podcasts. And of course, you can always watch it on Law and Crime's YouTube channel. I'm Melly, and we will see you next time.
You didn't see this young man getting out of the Jeep at any time, correct?
No, sir.
A high-profile trial with a high-profile defendant. Who better to discuss the case of YNW Melly than Johnny Depp's attorney, Ben Chu? Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. All right, so we're back breaking down the latest in the YNW Melly murder trial. This is, of course, the trial of the Florida rapper whose real name is Jamel Demons, and he's charged with the murder of 2 fellow YNW group rappers. This is Christopher Thomas Jr., or YNW Juvie, and also Anthony Williams, or YNW Sack Chaser. These men were found shot to death on October 26, 2018, after Melly's co-defendant, Cortland Henry, also known as YNW Bortland, pulled up to a hospital with the bodies of Thomas and Williams in the car. But he claimed they were all the victims of a drive-by shooting. Just so happens Henry had no injuries on him, and when law enforcement looked a little bit closer at this, they saw this as a staged scene. They say that Melly was the shooter, that he got out of the car before arriving to the hospital, and that he attempted to stage this as a drive-by shooting. They even highlighted how the defendant was a member of a gang called G Shine Bloods and maybe he did this as a form of loyalty to the gang. I have something else I have to mention. This is a death penalty case. So if Melly is convicted, he could be sentenced to death. Now, the law in Florida has changed. Normally, it was always a unanimous vote by the jury to vote in favor of death. The law has changed, and now you only need an 8-4 vote by the jury to vote in favor of death. Pretty incredible there. And when we think about some of the most heated and the pivotal moments in this case, I want to bring in a very special guest, somebody who knows about high-profile cases and high-profile clients. I'm joined right now by Johnny Depp's attorney, Ben Chu. Ben, good to see you. Thanks so much for coming back here on Sidebar.
Thank you very much for having me, Jesse. Thank you very much, and welcome back from your honeymoon.
Oh, thank you. Thank you so much. I'm trying to get back into the swing of things a little bit, but it feels, I would say it's like feeling like a glove, but it feels like a ring. You just put it back on. It's all easy. Let me ask you, not a hard question. Who's winning this case? I know we're really at sort of the beginning. The prosecution's still putting on their case. They have a lot more to present. But so far, can you get a sense of whether or not the prosecution or the defense is kind of taking the advantage here or winning?
Jesse, I think on balance, the prosecution seems to have the upper hand. I know that the defense has poked a few holes. In particular, they can't identify the murder weapon. But I do think the prosecution is put forth a fairly solid case.
What makes you think that? Because if you ask me, I think it's that surveillance footage of YNW Melly leaving the recording studio on the night of the murders. He gets into this car, this Jeep Compass. The two victims are in the car as well. And then prosecutors say that if you look at particularly the cell phone data, he's with them 15 minutes before Henry goes to the hospital with the victims in the car. So that's for me. And by the way, there was a 40 caliber bullet, a 40 caliber shell casing found in that car. Prosecutors want to suggest it was actually found near where Demmons was sitting. Is that the kind of evidence that you think is really strong for the prosecution?
Yes, Jesse, that's actually what leapt up to me as well. That combined, with the dog who didn't bark, there's no evidence of this alleged drive-by. There's no evidence that ever happened. But I think what you pointed to is really particularly strong.
Yeah, and they seem to suggest that the bullets that were fired at the car happened after the shooting of the two men, right? So that they were already shot at after they had been shot. And so it was meant to stage it to look like a scene. And as I mentioned, one of the, Mr. Henry, had no injuries on him. Very weird that two victims were shot and he seemed to be fine. Now, I have to ask you about the defense a little bit, and I'm going to play a portion of their opening statement. Let me play it right now.
What happened here is that the lead detective, Detective Melly, saw a video of Mr. Demmons getting into a car plus minutes before bodies were found in that car. And then he discovered that Mr. Demmons was a rising star. And from that point on, he decided he's going to commit this crime. Because if you're involved in prosecuting a star, you become a star. This was his big break. And he had tunnel vision. He zeroed in on this person, this young man, as the only possible perpetrator of that crime, to the exclusion of all other leads and evidence.
So as you heard, what they're saying is that you have a famous rap artist and law enforcement immediately zeroed in on him because you go after the famous people, you prosecute them, you go after them, it makes a bigger career, it turns your career up. You go after the famous people, you become famous. Do you think that's a good argument? And I'm glad I have you here to talk about that, because there is something to be said about you just go after the most high-profile person to make your case.
It could be a powerful argument, but for the circumstances of this case. And here they didn't go after Melly right away. In fact, it took quite some time before they ultimately arrest him. So I think it's a rebuttable proposition by the prosecution that no, we actually took our time before we decided to indict here.
Do you think there's any truth to what the defense is saying, that this was a sloppy investigation, that this was a botched investigation, that didn't question before, again, turning themselves to Melly?
I don't know enough to know whether that has any merit. I know that's an inevitable argument. They don't have many cards to play. That is the defense. And this is an inevitable argument they're going to make. You're picking on our client because he's well known, he's a rapper, he may be disfavored, and you didn't look for other suspects. So I think this is kind of standard out of the defendant's playbook.
When you're streaming Law and Crime on your TV or watching our videos on Facebook and TikTok, sound and audio quality is really important so you can hear all of the facts. That's why we want to tell you about Raycon is on a mission to prove that you shouldn't have to pay an arm and a leg for quality sound and essential smart tech listening features. You can get a pair of earbuds and a spare one and still pay less than you would with some of the other big name tech brands. These earbuds are water and sweat resistant. They have 3 customizable sound profiles and custom gel tips to fit your ear perfectly. They're great for working out, traveling on your commute, or listening to our Sidebar podcast, of course. You can get 15% off by clicking in the description or by going to buyraycon.com/law. Plus, get free domestic or flat fee international shipping, all Raycon.
I want to get your opinion on another big moment for the defense, or I should say, it was a potential big moment for the defense. We saw the testimony of Felicia Holmes. She was an interesting witness, very controversial. She was the mother, or she's the mother of YNW Melly's ex-girlfriend. She had allegedly told police that she had spoken with YN Melly on the day at YNW Melly on the night of the shootings, that he had FaceTimed both of them. She said it looked like he might have been hiding and waiting for somebody, even though he claimed he was a victim of a drive-by shooting. She kind of recanted that, didn't know whether she said that to police. She said she felt threatened by the prosecution. There was even a suggestion that she was going to be paid off by the defense. They were going to financially take care of her, and when they didn't, she said that she would start basically cooperating with law enforcement. I'm going to play a little portion of her testimony.
And in terms of your conversations with the police officers that morning?
Yes. I do remember that they kind of bullied me and threatened my daughter to take her to jail for accessory after that. I do remember that.
Yes. And in terms of the statements that you made about what happened, you don't have any recollection of that? Did you read this statement multiple times?
I looked at it and I just didn't recall it, and I don't know.
And so you indicated you hoped you were truthful with law enforcement?
Yes, I did.
I have to ask you to be more definitive. Were you truthful?
I don't remember what I said to them back then, so if I was to tell you something now, I could be lying. I don't want you to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything. I want you to tell the truth.
Okay, that's what I'm doing.
Okay. So, Ms. Holmes, with regards to that day, did you lie to law enforcement?
I just asked and answered.
Excuse me. Hold on.
Now, the reason this is significant is because the defense filed a motion for a mistrial. They said what she testified to and what evidence was introduced during the course of her testimony was improper. It was highly prejudicial. We had our own legal analyst suggesting there was maybe a good likelihood the judge would rule in favor of a mistrial, would either have gone to a retrial, that would have been retried again, or maybe it was dismissed with prejudice, and that would be it. The judge denied the mistrial. Were you surprised that the judge denied the mistrial?
No, I was not surprised that the judge denied the mistrial, and I think the jury will make of it what they will. I mean, I think that it may be that they disregard her testimony in its entirety, given the discrepancies in her testimony.
I think the idea of, hey, we're going to say the defense team, the defense team was going to financially take care of a witness so that she provides favorable testimony. Have you ever heard anything like that?
I have not at a trial. I never had that actually come into a trial, which I guess gets to the point of the motion for mistrial. interesting issue.
That's the thing, too, and I want to make that very clear. Somebody who's following this case might say, well, the defense's motion for a mistrial was denied. What a big loss for them. The other way of looking at it is whatever legal issue they raised, if YNW Melly is convicted, he could use that as a form of an appeal and say the judge ruled incorrectly and his conviction should be overturned. So that's not the only time we might hear about that. Now, Ben, you've represented some pretty high-profile people, most notably Johnny Depp. That's how you and I met in Virginia when you were covering that trial. YNW Melly is a rather high-profile defendant. He's had a lot of outpouring support in the community and online. What do you think it's like representing somebody like him? Because he's not only facing a jury, but he's also facing the court of public opinion as well.
Yeah, I think it seems that he has a great deal of charisma. You can see in making a lot of gesticulations, during the trial. He's interacting a little bit. I think they're going to have to make a long and hard decision about whether he testifies, which will be a crucial decision.
I definitely want to get into that with you. But before we do, you mentioned his behavior, his demeanor. He's blowing kisses. He's laughing, praying, smiling. Is that going to bode over well with the jury?
I think a little bit of it might be all right. In other words, a stray gesture here or there, a smile to a jury member or to the jury in general. But I think you can really overdo it. One of the jurors in the Depp trial, for example, commented afterwards that he felt intimidated by Miss Heard staring at him, and he found it off-putting. So I think a little bit of that goes a long way. So I think he needs to be careful, and his team needs to be careful about overdoing it, because if you overdo it, it can boomerang on you, especially in light of his background, to the extent that gets into evidence.
Right. I guess the thing is, this is a double murder trial. This is incredibly serious. And he's accused of being part of a gang. The allegation could be human life means nothing to him. So if you put somebody on there, it's different than I would say, and I'm not saying it's exactly like that, but when we covered the Gwyneth Paltrow trial, that was about a ski accident. Not there were outlandish claims being made against Gwyneth Paltrow. There were parts, I think, of it where she was smiling and laughing with her attorneys. She won that case, not saying it's because of her demeanor, but I think that would have been acceptable. Like, oh my goodness, what an outlandish claim to be making here. But this is a double murder trial.
Yeah,
and this is very serious.
That's a great distinction. I think what might pass in that case would not have the same effect here, which is why I said less is more. I think he needs to be careful with that.
You would advise him to, maybe change tactics here.
And keep it serious, absolutely.
Well, now you know what I'm going to ask you. I'm going to ask you the $1 million question. Whether or not you would recommend for him to take the stand if you were representing him, or whether you think he's going to take the stand. Now, obviously, it's a defendant's choice. This is not a self-defense case where sometimes you would need them to take the stand and explain why they use lethal force. Here's just a question of he's saying he didn't do it. He's not the killer. Will you think there'd be any advantage for him to take the stand?
Well, I go back to the point you made at the outset, which is so crucial, that you now only need 8 out of 12 in the jury to convict and to impose the death penalty. If it were the standard rule, which it has to be unanimous, I might be more inclined not to have him testify and just hope that you have 1 or 2 who are against the death penalty, period, and who somehow didn't disclose that during voir dire. Because I think there are many people who are against the death penalty, and even though they say that they can impose it possibly, I think there's always a possibility that there's somebody on the jury with that. I think he's got, he has to convince 4, essentially. Obviously, the prosecution has the burden, but as a practical matter, he needs 4. and he may decide, or his counsel, it's his choice, as you said, he may decide he needs to do it.
I also wonder if he would do it to not only clear his name, but clear any kind of image he has in the court of public opinion, right? In your case, in the Johnny Depp Amber Heard trial, that was a civil case. But one of the big things that your client did was, and if you speak to anybody who was following the trial, they said he did much better than Amber Heard on the stand. And he kind of rehabilitated his image on the stand. And you know, that was, I felt it was kind of necessary for him to give his point of view and say what he said. I'm curious if Melly's doing the same thing. I mean, he's accused of double murder. If he might be saying, my fans want to hear from me, the world wants to hear from me. Yes, I have to convince this jury, but maybe it's more important for him to tell his side of the story in an open platform like that.
He may well think that. And if that is his ultimate decision, and we're speculating, obviously, he's going to have to spend a lot of time figuring out how he's going to explain some of the things in his background. And you mentioned the gang membership. I think he's going to have to kind of own that up front and try to explain that, and explain that before the prosecution gets to him. In other words, he would need to explain the problematic aspects of his past before the other side gets to him first. And that's something that they would really want to think very carefully about, because his record is problematic, as you know.
It is. How difficult is it representing a high-profile client like this?
It can be difficult. I mean, I've been blessed, the high-profile clients, and I've had several. I've been fortunate. All of them have happened to be very thoughtful individuals who are capable of listening and really taking in. They didn't accept, you know, Mr. Depp obviously didn't accept everything we told him, but he listened to it. He took it in, and he adopted much of, at least some of our thinking. I just don't know the extent to which, you know, Melly is listening to his lawyers. Hopefully, for his sake, he is. Because he's got good lawyers, and if he's listening to them together, they could probably work on something that would be more palatable than if he were just trying to do it on his own.
And there's so much at stake here. It doesn't get more at stake. As I mentioned, his life is on the line. If he's convicted, it's not just life in prison we're talking about. We're talking about the death penalty. What's your take on the fact that the Florida law changed and it's no longer unanimous and it's just going to be 8-4 in favor of death?
I'm not a big fan of that. Of course, I'm a native of the District of Columbia, not Florida, but I think that's very unfortunate. I think if we're going to have the ultimate penalty, I'm not a big fan of the death penalty, but if we are, I think the unanimity is one of the system has, and that's now gone in Florida. And I think that personally, this is just my subjective opinion, I think that's a shame.
And Ben, I'll be the first to tell you, this trial was not on my radar months ago. You know, this case wasn't. I just so happened to be on my honeymoon. And as I'm on my honeymoon, I heard about it. I heard about YNW Melly. It was all over. Everybody was talking about it. Are you surprised that it got the attention that it got? Because I'll be straightforward with you, too. When your client, when Johnny Depp Amber Heard was happening, I don't think a lot of people were talking about it. And then it started up, and it blew up. It just became a mammoth of interest. Are you surprised that we're seeing the level of interest we are in the YNW Melly trial?
Well, I think part of it is a function. I am a little surprised, but part of it is a function, I think, of what else is going on in the world. And I think part of it is we're now in the summer. Our trial, so the Depp trial, also in April, May, and ended with the jury verdict on June 1st. I think in a way, these trials are important in themselves, but also a version from said Melly is extremely popular, and I think that really got.
Look, even though there's some strong evidence, I think, by the prosecution, I mentioned the surveillance, the ballistics, the idea that, you know, his co-defendant had no injuries on him, him. There's that question. Reasonable doubt. What was the motive for him to kill his friends? Was it about money? Was it about gang loyalty? Does it make sense? People are into. Ben Shu, pleasure as always. You are a gentleman. You're one of my favorites. Thank you so much for taking time. Thank you so much. Everybody, that's all we're on Sidebar. Thank you for joining us. Please subscribe on Apple Podcasts, Spotify, YouTube, wherever you podcasts. I'm Jesse Weber. I'll speak to you next time.